Hey, I'm Paul Rabley, and in this video, we're going to talk about the second of 5 ways that a married person can leave their estate. So I'm Paul Rabley, estate planning attorney, helping our clients in and around Louisiana get and keep their legal affairs in order. This is part 2 of a 5-part series on how married people leave their estate. Part 1 was about leaving ownership to their spouse. You can check out that video for more information. And in this video, we're going to talk about how a married person can leave their estate in trust with their surviving spouse as the trustee. Now, know that married people can leave their estate a variety of different ways or use a combination of the 5 ways that I've been talking about. But we're going to talk about in this method, it's leaving their estate in trust with their surviving spouse as trustee. They can either do it through their will or they can do it through their revocable living trust. If they do it through their will say something like, I leave my estate or I leave these assets of my estate in a testamentary trust, and I name my spouse as the trustee of that testamentary trust. It'll say a lot more than that, but that's the gist of it. So a testamentary trust is a trust that is part of someone's last will and testament, hence testamentary trust. So that's the way to do it through a will. If you have your revocable living trust, or you and your spouse have your revocable living trust together, it might say something like, upon the first spouse to die, the assets of the trust get split. One part of the assets that were the assets of the first spouse to die go in one trust, and the assets of the surviving spouse go in another trust. And then now we're talking about the trust that's the assets of the first spouse to die. So here's what those terms usually look like. Like I said, it can be done either through a will or through a trust. The terms usually say in this method something like, I leave my estate in trust for the benefit of my spouse and my kids. It will probably say something like, my spouse shall be the income beneficiary of that trust. And it might say that my spouse will be the income beneficiary of that trust for the rest of my spouse's lifetime, or maybe for a period shorter than that. Probably says something like, my kids shall be or my children shall be the principal beneficiaries of that trust. And then it will probably say something like, the principal of the trust can be used for, and it might say, the health, education, maintenance, and support. HEMS, health, education, maintenance, and support. Kind of call it the HEMS standard for short. Principal can be used for the health, education, maintenance, support of the income beneficiary. So what does all that means? It means if, let's say the husband dies first and he's, leaving it this way for his wife, and maybe he has a home, maybe he has money, maybe he has investments. He's saying that when he dies, his assets will either go or remain in trust, and his wife will be the trustee of that trust. So she'll be the one, if the house needs to be sold or if the investments need to be invested, then she's the one in control of that. She's the trustee. It also says the spouse is the income beneficiary of that trust, meaning if the investments produce some income or the CDs produce some interest, then she gets that income. Now she gets it, she'll pay income tax. She'll pay income tax on it. Trust won't pay any income tax. So she'll be what's called the income beneficiary. And then in order to kind of protect that husband's children, the husband will provide in that trust that his children are the principal beneficiaries, meaning that when the surviving wife dies, when her income, her interest in income terminates, then the principal will be for his kids, or the trust assets will be for his kids. So it's really a way for him to provide for his wife, but then make sure that when she dies, those trust assets revert back to his kids. She won't be able to redirect where that principal goes. So let's analyze that a little bit further. It still puts the surviving spouse in control of everything. So the surviving spouse, she'll be the trustee of the trust, so she'll be in charge of managing everything. And she can really she'll get all the income, and she can access the principal if she needs it for her health, education, maintenance, and support. And I realize people may differ in whether a certain distribution would be for her health, education, maintenance, or support. But if that surviving spouse is the sole trustee, she's the one who gets the first shot at determining, what distributions are appropriate for her health, education, maintenance, and support. So it really puts that surviving spouse, in control of everything, but designed to protect the principal. when the surviving spouse passes away. You know, that surviving spouse can't redirect the principal to a new spouse or to someone else. When the surviving spouse dies, that trust principal has to go back to the first spouse to die's kids. Hope you're sticking with me here. All right, the concern that some people have is, wow, I'm giving my spouse too much control and I'm not giving my kids as much protection as I'd like to give them, my kids or my heirs, whatever you want to call it. So some married people might say, well, if my spouse is the trustee and my spouse gets all the income and my spouse can use the principal for her health, education, maintenance, and support, what's going to keep her from just pulling it all out of the trust and giving it away to somebody else or leaving it to somebody else? You know, that could get sticky if that my spouse is that sole trustee of that trust. That's a lot of power, and it is. So, but quite frankly, a lot of married couples are comfortable with that and wind up selecting that as the method by which they leave their estate for their spouse and ultimately for their children or other heirs. Let's take a look at the tax consequences to all of this. The estate tax, well, the assets of the first spouse to die, they're not going into the surviving spouse's name. They're staying in a trust for the benefit of the surviving spouse and the kids. So in the typical sense, those assets of the first spouse to die are not going to be lumped into the estate of the surviving spouse for estate tax purposes when that surviving spouse dies later on. Probably not an issue because of our $11.4 million exemption. The income tax, well, the surviving spouse is the income beneficiary of that trust for the rest of her lifetime. So as those trust assets produce income or interest or dividends or rental income, that's all going to go to the surviving spouse, and that surviving spouse will continue to report that income on their personal return. On a capital gains tax standpoint, again, typically when the first spouse dies and he leaves his estate in trust for his surviving spouse, those assets will not be included in the estate of the surviving spouse, so they won't get another step up in basis when the surviving spouse dies. That's not necessarily a good thing. So you don't get that double step up in basis like you do under some of the other methods by which you can leave things to your spouse. So who does this? I would say the people who do this, leave their estate in trust with their spouse as the sole trustee. Their general goal is to make their estate available for their surviving spouse, but they don't want to give their surviving spouse so much control that the surviving spouse could leave it to people other than the heirs of the first spouse to die. So you're making it available to your spouse. They're in control. They get the income. They can use the principal for their health, education, maintenance, and support. And then there's, protections in place for the children of the first spouse to die, because the trust says when that surviving spouse dies, the trust principal must be for the principal beneficiaries, who are typically the children of the first spouse to die. So, that's the scenario. We see it a lot in maybe blended family situations where husband or wife, but let's use husband as an example, says, wow, I got my 3 kids. My wife has her 2 kids, but I want to take care of my wife, but I want to protect my kids. So when I die, my assets, they're going to go in trust. My spouse can be the trustee. I trust her. She can get the income and she can use the principal if she needs it. But when she dies, I want that trust principal to go back to my kids. I don't want it left to her kids. So we see this a lot in those blended family situations. Okay, so I hope that helps. This is number 2 of 5. Got rolling right into it. Got 3 more to go. Got 5 ways a married person can leave their estate. So check back tomorrow, or if you're watching this, as soon as it gets uploaded. But the next 3 are going to be the other 3 ways married people can leave their estate. This is number 2. All right, make sure you subscribe. Real important, so you'll get, however YouTube or whoever notifies you when we do new stuff, and you can learn more. So subscribe, hit the notification bell, punch the thumbs up button, and then share some comments below on things that you think could be constructive and helpful to other people. That would be fantastic. And if you have some questions or there's other issues you'd like me to address on these videos, I'll read the comment, put it in there, and I'll take a look at it. Try to be, as kind of grammatically correct as you can on your comments, and we'll take it from there. All right, y'all have a great day. See ya.